Welcome to this PropAcademy webinar, which is hosted by PropAcademy, a faculty of CTU Training Solutions, and I am representing CTU as well. We are going to discuss the importance of being ahead of the game with bad tenants. I think, again, a loaded topic. So I think to start off with, Courtney, please introduce yourself and we'll take it through from there.
Awesome, I will do. Thank you so much, Colleen. So my name is Courtney, for those of you who haven't met me. At PropAcademy, we're passionate about supporting the real estate industry. And these free webinars are our way of making sure that you stay informed and empowered. So I just really want to thank you for joining today. I actually love these discussions. I love learning and I love the latest input. So I'm looking forward to it. And I'm going to hand over to Alison. Alison, if you can introduce yourself.
Thanks, Courtney. Hi, everyone. My name is Alison Laxton. I'm an associate attorney at SSLR. I've worked in my previous life as a director of my own law firm as well as the head of a law school. I've also served as an HR manager, so plenty of diverse experience there. SSLR, as you may know us, or if you haven't heard of us before, we are a property law firm. We've specialized in property law. We have opened up some additional branches, so IP, labor, and compliance, but we do specialize in property and we have for many, many years now. So I hope that everyone who's joined us here today will find the session insightful and hopefully you'll learn something new. Thanks so much.
Hey, Marizel, over to you.
Thank you so much. Thank you, Ali, for the wonderful intro about SSLR as well. So my name is Marizel Coetzer. I'm also Cape Townian in Blueberg. So yes, representing the Cape Townians here today. So I work in SSLR myself as marketing and HR. I'm in our Cape Town branch. However, I was also a real estate agent for many years prior to joining the team here at SSLR. I also had my own properties. I was a landlord myself, and I was a tenant myself. So I really covered all the ends of the property industry, rented out properties, renting properties, buying, selling, all of that. So I'm super excited to share some high-level info with you today, some golden nuggets that might just help with your rental journey and your property investment journey along the way. But we're super excited to be here, and thank you for allowing us and for giving the opportunity to join you here today.
Awesome. Thank you so much. And so there's a stereotype that a lot of webinars are 50% introductions and 50% content. We're here to break that rule. We don't do it that way. We're going to jump right into our topic of discussion. So Marizel, I'm actually going to start with you. So my first question is, before placing a bad tenant, how can a landlord identify one from the start?
So thank you, Kathleen. I think that is one of the biggest questions that a landlord should keep on reminding themselves about. So it all starts with the viewing, and then we jump over to the tenant vetting. But if we start with the viewing of your property, I am a firm believer that it's always best to do the property viewings yourself as the landlord or the owner of the property. The reason being is it will allow you to build that first initial contact and relationship with the tenant. So if you immediately see the tenant obviously getting out of the car and walking towards you, already get that feel. Now, I'm not someone that says judge a book by its cover, but those first impressions do last. So I had to conduct a viewing myself at one point, and I was waiting for the family to pitch up, and the mom got out of the car with a small boy, and then the father got out of the car with a beer bottle in his hand. And I was like, oh wow, you see, this is the reason why we should conduct viewings, because that is how it will already give you an idea of the type of tenant that you're dealing with. So if everything went well in terms of the viewing, then it's very important to ask the necessary questions when it comes to the tenant vetting. And that is obviously to look out for some warning signs. An example would be as if you ask for an additional document. Let's say, for example, you see that the tenant's credit score is quite high, meaning they're high risk. That means there might be something off or dodgy about that. And usually you will be able to pick it up, whether they on debt review, and you might ask for a confirmation letter of the debt review. And if the tenant really takes some time to provide that to you, or they have some excuses why not to present it to you, or they say, no, this is confidential, it's already a red flag. Another thing could be is, and it's not, I'm not stereotyping here, but if a tenant finds himself in a new job, it's always good to actually phone the company and to do employment reference. But just keep in mind, if a tenant starts a new job, there might be a probation period. So just ask the HR consultant, listen, this guy will need to go through probation. What happens thereafter? Is it a contract employment or a permanent employment? And another tip that I would like to give is, when you do the vetting, always try and Google the company and phone their office number. It's usually a landline number and not a cell phone number, because this tenant could potentially tell their manager or a co-worker or colleague, listen, I'm going to give you up for employment confirmation, just so everything is fine. Whereas if you phone the actual landline, you will get to the correct people and they will tell you, yes, this person is permanently employed, or no, it's not. So obviously, another thing that we can take into account when doing the tenant vetting is, if the tenant just merely takes long to submit their documents, it means initially that they might take long to submit their documents, which means you can also wait long to receive your rental payments in the end, because that shows a really type of behavior from their side in the urgency when it comes to paying the rental, for example. And then, as I said, the background checks, check for criminal records, judgment records, the employment confirmation. And a very crucial thing that I usually done in the past was to do a previous landlord reference check. But I don't just ask the tenant for a cell phone number of their landlord. I would usually ask for their previous lease agreement, because the tenant, the landlord's details will be on the lease agreement, or the agent, or if it's been rented out by a trust, usually the director of the trust will be there as well. And you can phone them and you can ask them, listen, how was this tenant? And the one thing that I usually got is, most landlords will tell me, oh, I didn't know that the tenant actually gave notice. And this will also give you an impression on how the tenant would be, because this means that they are actually looking for an alternative property before giving you notice. So you are left in the dark, and all of a sudden they find this beautiful mansion that they want to move into, and you're left with a tenant, you're left without a tenant after a weekend when they decided to move out. So it's crucial to do those small checks in doing a tenant vetting before even placing a tenant to make sure. So I just want to quickly summarize this answer is, make sure the tenant that you do the viewing with, that you actually meet them personally and check them out. There's nothing wrong with that, because obviously they will become the people that will take care of your investment in the end. Then also, when you do the tenant vetting, make sure that they submit their application documents in a timely manner. Do those checks, the employment reference check, the previous landlord reference check. It is so important. It does seem a bit admin-intensive, but it's quite crucial. Make sure they don't have any judgments or criminal records. And if they do, ask them for supporting documents. There's nothing wrong in asking for supporting documents. And if they're hesitant to share it, you might know that they might be hiding something. So yeah, in general, that is high level what I can suggest, a few golden nuggets when pointing out a bad tenant before even placing them, just to protect your own risk.
I must say, and if it's okay with you, Marizel, to contribute to what you've said, I was on the receiving end as a manager for an employee who started a new role and applying for a rental spot, and you know, the irony is that employee was a bad employee as well, but we didn't know it at that point. It was still the first 2 weeks. So I had the landlord phone me, and obviously I did mention to them they're brand new and we can't give you any feedback on their, you know, reliability yet. And I think what stood out is there is a risk with someone starting a brand new job, especially if they're not married, especially if there's not a person that's with them in the process that's reliable. So I just thought that was quite interesting, because it took me back to that scenario, and I felt bad for the landlord, because I realized once everything had played out, the landlord was the next person to feel the brunt of this situation. So yeah, asking
Absolutely.
all the questions, taking extra steps. Yeah, I think that's so vital. And then to follow up on that discussion or that statement you made, Marizel, how can a lease agreement exercise more control over problematic tenants?
I love this question. Thank you, Colleen. So the reason for that is obviously after you've done the viewing with the tenant and you moved into the application, now you've done all the checks. You spend an evening after dinner going through all the bank statements and everything. Now you've finally found someone that you think is perfect for your property and such a suitable tenant, and we all hope for that. And now we just want to get the lease signed. You know, it's now like, okay, let's quickly wrap this up. We want the people to move into our property. We don't want to lose them because remember, most tenants also, they're in the market for a rental. So we want to get the lease agreement out as soon as possible to the tenant, not to lose them. So we want to look them out in. But it's so crucial to please take your time with the lease agreement. And this is the basics, it's the cornerstone, it's the fundamental groundwork of your relationship to come with that tenant. So to get it out of the way will just burn you in the end. So things to look out for or to keep in mind to just manage any tenant, whether they might become problematic or not, is to make sure that you as the landlord understand each and every clause of the lease agreement. Now, at SSLR, we are partnered with TPN, and we have a full lease agreement series on the SSLR Facebook page, where you can actually visit and watch all those videos to understand the lease agreement. So it's extremely important for you to understand each and every clause. Then make sure that you have key clauses, especially in the addendum, that protects you as the landlord and necessarily the tenant as well. But things like, when is utilities being invoiced? Is it prepaid meter or not? What about pets? Are pets allowed in the property or not? Is it smoking? Yes or no? So all of those type of addendum clauses, although it will take some time to set it up, it will protect you in the end, because if the tenant now all of a sudden smokes in the property and you know it's actually a non-smoking property because you don't want it to be in, you know, lingering in the house, the smoke, then you can fall back on the lease agreement and say, listen, but I did indicate it's a non-smoking property here. So okay, let's quickly discuss this dispute and let's see how we're going to resolve this. Whereas if you're just going to leave the addendum blank because you don't want to waste time or admin filling it in, you might just pull on the shorter string in the end of the day. Another thing that I want to highlight is the breach clauses of the lease agreement. So in the TPN lease agreement, it's usually clause 23 and clause 24. Make sure that you understand what it means when a tenant is in breach, when the tenant is in breach, and obviously what is the next steps, how to handle the tenant when they're in breach. And similar to you, remember you also as the landlord have a responsibility to maintain this rental relationship. So make sure that you maintain your responsibility not to be in breach, because I usually say tenants are a different kind of species, although I'm also a tenant currently now myself here in Cape Town. But we are weird. We know everything about the lease agreement. We know everything about the Rental Housing Act. So you as the landlord must make sure that you know all the clauses. I want to say off by heart, like just have a very in-depth understanding of that. Make sure you know the addendum, make sure you've added all the clauses in the addendum, and make sure you know what to do when your tenant becomes in breach of that lease agreement, and that you have the necessary people to go to ask for advice whenever that happens. So again, this is just in general. We can really have a separate session on just the lease agreement and how to protect you as the landlord, but just make sure it's watertight. Make sure you fill in that addendum. Make sure you have everything there. For example, if your property comes semi-furnished or with a few appliances, note it in the addendum saying the property came with a fridge, washing machine, a dishwasher, for example, And if any of those parts break due to not fair wear and tear, you as the tenant will be responsible. Things like that. It seems so irrelevant at the beginning because you just want to get it out of the way. But in the end, it will really save you quite a bunch of money.
Yeah,
Kind
and
of
you do.
feels- Oh, sorry. Yes, Courtney.
Sorry, Colleen. And you also get like, if you I always like, because I was an agent, well, I still am an agent, but I used to do rentals, and you sometimes get these good feelings like, oh, but she's such a nice lady, and then you start, or maybe it's even a referral, a friend referral, and you don't take it so seriously, and those are the ones that will come back and sort of hit you, you know. So you've got to treat everyone, I feel, with the same paintbrush. You've got to paint them with the same paintbrush, and you've just got to make sure everything's watertight. Like you say, don't get relaxed and be like, oh yeah, it's chilled. We'll just repair this. It's actually for your account, but we'll do it, because then when the next thing happens, you're the one who's actually now caused the confusion instead of sticking to the document that you need to follow.
Yeah,
and you know what?
No, I would just wanted to mention it's that whole quality over quantity principle. You're going to have expensive errors in the long run if you don't go through that process.
I 100% agree with what both of you said. And I mean, the lease agreement is like the heartbeat of the whole relationship, and whatever happens always fall back to the lease agreement. And obviously the lease agreements that we use as SSLR and that we suggest are 100% aligned with legislation, so you cannot go wrong with that. So whenever there's a dispute, it's always so easy to get that out of the way and kind of sort it out when you just fall back onto the lease agreement and you make sure that everything is stipulated there. And really, I'm saying this with such an open and honest heart that if you ever need any help, I mean, we are here. There are people, there are lawyers to support you, just to peruse your documents to make sure, okay, cool, maybe you should add this, or maybe just look at that, because in the end, you will just save so much emotional trauma, then obviously finances as well, when you know that your lease agreement is very well drafted.
Absolutely. I think before we go on to the next question, and Alison, that will be for you, I just want to remind our audience, as you see, we've got almost 130 people in the session. Welcome again. Thank you so much for joining us. Just a reminder, post your questions. We will address them near the end, even if it's a question to one of our earlier discussions, we will address them. And we are only going to post contact details in the end, because we found if we post them too early, people miss out on the, have to scroll back to the chats. We're just going to leave it at the end. We will share contact details. Just give us a moment to get through the majority of the session. But yeah, just a reminder there to our audience. Also, if you joined a bit late, we're not going to unmute mics or cameras. So if you have a verbal question, unfortunately, we don't follow that format here. Please use the chat to ask your specific questions. Okay, so Alison, this one's for you. What can a landlord do when the tenant is overdue with their rental or even their utility payments?
I think I want to tie back first to what Marizel says, and it's the biggest issue that I see with landlords who come to me where their tenants are paying late, is they have wanted to save pennies and they don't get a proper lease agreement. They DIY something, they go use ChatGPT, and that can be a disaster. So the first thing you do is you make sure, like Marizel has said, you have a reliable, properly drafted lease agreement. And then you go back and you look at that lease agreement, right? Because if it's a well-drafted lease agreement, it's going to talk about what happens when rent is late. In essence, what happens when you have a tenant who has breached the lease agreement. Now, remember, especially in residential matters, we still have this constitutional right to have housing. We don't want to be chucking people out of their homes unnecessarily. So you need to make sure that you go back to your lease agreement and then you will send a letter of demand. If you don't know how to do this, you will get in touch. Like Marizel has said, TPN has templates, or you will contact your attorney to advise you on how to send that letter. Now go back to your lease and have a look at the time periods. You should have a clause around how to remedy that breach. Right, things happen, people end up in hospital with unforeseen medical bills, or something happens and they've had to pay out a chunk of money and they ask for a week or two of grace. That's okay. If you can come to some sort of signed and agreed to settlement on when they will pay you, go ahead and do that. But if you can see that this is going to become a problem tenant, you send that letter of demand and you give them a time period to remedy that breach. Now, what's very important to note in your lease agreement is if your lease talks about business days, please make sure that you know how to count business days. We see this often with clients where they include weekends, they include public holidays, and it's talking about business days, right? So once again, comes back to being comfortable with your lease and feeling empowered to use that lease agreement. And once that person has received that letter of demand, you must make sure that they actually receive it. So we usually advise that you go and you hand it to your tenant physically, send it via email or over WhatsApp, and make sure that you've got delivery and read receipts for those communications. It's so easy for people to say, my phone got stolen, or I got locked out of my email account. I didn't know you sent me a letter of demand. I couldn't pay. So in order to cover yourself as a landlord, make sure that you ensure that you have that proof of receipt of that letter. Now, make sure you diarize, and a good landlord will be someone who has open communication. Just remind your tenant that that deadline is coming up. Ask them if they're going to have challenges meeting that deadline, and keep that line of communication open. If you are overseas, you're traveling, you're on honeymoon, you can have a really good managing agent who can do this for you. They do it for a living, and they are much nicer than some landlords. They know how to work with the tenants. So if you've got a good managing agent, use them. You know, you're paying this person to assist you with managing your rental, and they will be able to guide you on how to make sure payment is not late every month. Now, something else that you can then eventually do is go ahead and cancel that lease. But remember, you have to do your letter of demand first. You have to follow your lease agreement, and you have to give that person a chance to pay. What is also prudent to note is if you are asking for payment by the 1st of every month, Marizel spoke about doing those salary checks, right? People get paid on different days, and most people get paid before the 30th. Some people get paid as late as the 7th of each month. Now, in terms of the labor legislation, they can pay you by the end of the first week of the following month. So just chat to your tenant and say, when was your previous lease agreement? You know, when did you pay? What suits you? It doesn't make sense to ask for payment on the 1st if this person gets their salary on the 5th or 6th. So make sure you also know how your tenant is being paid so that you don't set them up for failure. Have that open conversation, see when they can pay you, and make sure that it's proactive. Something I also see, and I just want to expand on this question because I've had a client literally on the phone with me this morning. Don't have a soft heart. And I know that's something funny to say as an attorney, but what we see landlords do is they try to make informal settlement arrangements. There's nothing drafted in writing and signed. Yes. And so one late month becomes 10 late months, and before you know it, you are 100,000 Rand in arrears, and both the tenant and the landlord are drowning. The landlord's worried about repaying the bond, the bank's on his back, and the tenant is worried about how on earth am I ever going to afford this? So be proactive, make sure that you rely on your attorneys or on your managing agent to make sure that your tenants pay and meet their time periods. And like I say, TPN has a lovely pack. The letter of demand is included, and you can make use of that letter of demand to formally, request that that breach is remedied. So I think that that's a good way to handle, making sure that your tenants keep up to date with their payments. Unfortunately, the next thing that follows when non-payment becomes a very regular thing is the cancellation of that lease and subsequent eviction. And prevention is always better than cure. So rather try to find that good tenant and then manage them well. If you're not happy with your managing agent and you can see that they're not following up proactively, look for someone else. Make sure that you have a good relationship with your agent to make sure that you don't have things that you forget and the tenant just says, oh, well, my landlord never really cares, and so I'll just pay them when I feel like it. So yeah.
You mentioned eviction, and I think that leads to my next question or request is if you can explain just in a nutshell how an eviction process works in South Africa.
So we have different types of evictions, and it's very important to note that different legislation applies to different types of properties. So residential evictions, we have to follow what is called the PI Act, Prevention of Illegal Eviction, from Unlawful Occupation of Land Act. Very long name, we just call it the PI Act, so much easier for laymen to understand. That's for residential premises. So any building where people are using it to dwell residentially, you have to follow the provisions of PI, right? You can't just go and take the law into your own hands and lock your tenants out. Please do not do this. As attorneys, as a law firm, we see landlords come to us crying because now the tenant has a claim against them. So I see it on Facebook all the time. Please avoid your community groups for legal advice and consult a property attorney. So much bad advice is out there about having people move in with your tenants, get rid of them that way, start renovations, cut off the water, cut off the electricity, change the locks. It is possibly the worst thing you can do, and your tenant will have legal recourse against you as a landlord, and it will just delay your entire eviction process. So the golden rule of eviction, especially with residential eviction, is that you need a court order to lawfully evict someone from premises. That is unfortunately how it works. The wheels of justice turn slowly, but they will go a lot more slowly if you do not follow the correct protocols. So very important to note that. So step one, we can summarize it in 7 steps, but step 1 is sending your letter of demand, right? So you've got a good lease agreement. The lease agreement talks about breach, what happens when non-payment is not remedied. You go to your lease agreement, you look at those time periods, and you send that letter of demand. You make sure that letter of demand has been properly delivered and received, and you count your business days. Usually it's 20 business days, and you wait for that tenant to either remedy the breach, settle with you, enter into some sort of acknowledgement of debt or settlement agreement, or you wait for them to do nothing, right? But that is the most important thing, is you have to send that letter of demand because you are placing them in breach. Now, the next step is that you will draft, or your attorney will draft, a founding affidavit, and they will start asking the court to have an eviction application launched in the correct court. You'll usually go out of the court that is closest to the premises where your tenant is residing. So if your tenant is in Ferndale, you'll go through the Randburg Magistrates Court. Now, very important to note is that you will be cancelling that lease, and then you will be proceeding with your application process before the court. This is something that your attorneys will do. Now, you'll also have what is called a Section 4.1 and Section 4.2 notice in terms of PI. The sheriff will then go and serve that on the respondents, and you will also get a date for when that eviction will be heard. Now, the tenant has time periods to comply with to defend this, right? And if they don't, you go ahead to court, and if they defend it, you have to follow the defended legal process. But essentially, you will go to court and get a date, and the court's going to consider various things. They're firstly going to consider, did you follow the correct legal process? So in other words, have you placed your tenants in unlawful occupation? If there is any chance that your tenants have lawful occupation, your eviction order will not be granted. So this is why it's so important to consult with an attorney and to make sure that they follow the correct 7 steps for you. Now, they're also going to consider various things. If your tenants are disabled or elderly, or if they are unemployed, or if there are children on the property, you need to make sure that you are not going to be putting them out of a home and they will be on the street, right? So your constitutional right to housing is going to apply here. The court is going to look at equity and justice, and they are going to consider the personal circumstances of those tenants as well. So if you're a landlord wanting to evict people, and you know that one of them is in a wheelchair, some of them have severe disabilities, or there are children on the property, you must consult with your attorney and make them aware of this, because it's something the court will consider. All right, so very important to note that, and if it becomes opposed, you will have to get an attorney to assist you with how to handle that opposed eviction. Now, just note that we have different forums, and usually your eviction applications go through the courts. With your landlord-tenant disputes, you go to the rental housing tribunal. So really important to make sure that whatever your dispute is, or however you're trying to get someone out, that you do consult with an expert property attorney and they can guide you on the process, especially if PI applies. PI is such a comprehensive piece of legislation. And we see a lot of, our human rights lawyers engaging with it very successfully, where landlords take the law into their own hands. So even if you are a landlord with a hijacked building, you have to follow this lawful process. It takes time, and be prepared, if the circumstances are hostile, to use the sheriff and to make sure that the sheriff has SAPs accompanying him as well to attend to that eviction. If you have attorneys, remember you pay us to fight the fight for you. So it's really important as a client to not do anything that could harm you as the landlord or frustrate you, and you then go to change the locks halfway through the eviction process. Always consult your attorney and make sure that you don't take the dodgy advice that's out there on social media, because it will cost you in the long run. So there are, let's summarize those 7 steps. There are 7 steps, and the first one is your letter of demand. You give them time to remedy that breach. The second step is you send that letter of cancellation, right? Because now you haven't paid me, I need to cancel, you are in unlawful occupation. That unlawful occupation underpins your eviction process. You then approach your attorneys, they will do an ex parte application for you, and they will issue what is called a PI application. They get a date and they attend court for the hearing. It can then become unopposed or opposed. If it is unopposed, your eviction will be granted and you can move on with your life and have fewer grey hairs. And if it's opposed, the tenant's going to argue why he has that right of occupation and why he should not be evicted. Now, as a tenant, we see this many times. Tenants will often get into personal disputes with the landlord. Remember that we also want you to be financially responsible and clever here. Don't spend money on attorneys when you could have entered into a settlement and you could have by now found a new place to live. Sometimes ego, being as the driving force behind litigation, is the worst thing you can do, either as a tenant or a landlord, and try to make decisions around evictions that are financially responsible. So I think from my side, that's really how we would advise you.
I think we lost Alison there for a minute.
Yes, I think she was also at the end of her question there. So
yeah. Alison, your internet just dipped a little bit now at the end, but I think you covered most of what you wanted. And I think what's clear is how sensitive this process is. And also, if you try and tackle it yourself in your, primitive ways, it can actually extend and worsen the process much more. So I think very, very valuable feedback there. And to continue on that, Alison, can you give us some insight into the landlord's rights and responsibilities when renting out their property and then realizing they have problematic tenants?
So I think it's really important to know that this is a reciprocal relationship. So you also have to make sure when you give a property to a tenant, it's got to be suitable for the purposes for which you are leasing it. If you are renting out a residential property, make sure that it is safe to live in, that the electrical compliance is up to date, that the geyser is functioning, that is a safe property to live in. So, also make sure that you are giving the property to them in a good order and that you are maintaining what you are required by law to maintain. If you are required to make sure that the property is maintained and doesn't have black mold and you've got to do certain renovations, you have to do that as the landlord. So even though your tenant hasn't paid you, you have to give them that time period to remedy the breach, but you can't withhold your obligations because of non-payment. You've got to give your tenant time to remedy that non-payment. You can't just start, doing things of your own accord or withholding your obligations. Now, also something a lot of landlords do is they don't realize you have an obligation to give that tenant undisturbed use and enjoyment of that property. So storming into your tenant's property as and when you feel you can is going to be interfering with their use and enjoyment. So just as tenants have the right to pay you a sum of money to enjoy that property, you've also got to make sure that that property is well maintained and kept in good order, and that you comply with all of your obligations in terms of the lease agreement. So deposits, something else we have so many fights about in tenant and landlord disputes. Know what a deposit is and know what you should do with it. A deposit is not your 13th check, okay? We've had so many landlords come to us and say, I spent the deposit, I don't know what to do. The person wants to go and now I have to pay them back. So know what to do with your deposit, know how it should be handled, and know what lawful deductions you can make on that deposit. I always say, in terms of duties, be clear. Make sure you do an ingoing inspection. Make sure you do an outgoing inspection. Your tenant should be present for that. If your tenant can't be present, they should authorize someone in writing to be there to take an inspection on their behalf, and you should have that in writing. Make sure that, all of your faults are disclosed up front. A lot of landlords will not tell tenants about the body corporate rules, and they will just want to get a tenant in and handle the body corporate later. But it's really important to note that you've got to be transparent and honest during this process. I've had clients come to me where they've got dogs who are over the height limit. They take occupation, the tenants are super happy, and the next thing the body corporate starts fining them, and the landlord or the managing agent completely misrepresented the situation to them. So that's really important to note that. And also remember that once you have cancelled that lease and you have proceeded with an eviction application, your tenant needs to make sure that they leave. If they don't leave as and when asked to do so, in terms of that cancellation letter, we calculate holding over damages as attorneys, and we ask the court for that. So please don't think that as a tenant, it's fine, you'll just stay there. You might be held liable for holding over damages if that eviction order is granted, and not just the arrears rental that you might owe at the time. So yeah, I think from a landlord's perspective, know your lease, know your obligations. And then I've spoken a little bit about some of the common law obligations as well between the parties there as well. So I hope that is clear.
Yeah, and I see we've got quite a few questions ready for you ladies once we get to the end. I think, Alison, I'm going to address the next question to Marizel. If you don't mind maybe typing the 7 steps in the chat, because I see that quite a few people are asking for the 7 steps that you mentioned. I think that would be quite helpful. All right. So I think, Marizel, this one's for you. And I think you touched on a few of these, but I think reiteration is quite important here, is to give us a few preventative measures that landlords can take to try and prevent their tenants from causing any problems.
Awesome. So there's quite a lot. And, being a landlord myself, it can be so overwhelming, because now you think, oh, I have to keep this in mind and I have to keep this in mind. And even an agent, I know this whole session is mostly focused on private landlords, but even for agents to keep it in mind. Usually when I was an agent myself, it becomes second nature, and you kind of, okay, well, yeah, I've done this, it makes sense. But as a landlord, and you maybe have only 1, 2, or even just 5 properties, and now you have to do this while doing your daily work, it's super important just to have a few things ticked to make sure that you have a good standing relationship with your tenant. And the very, very, very first thing that I always recommend is have an open and honest discussion with your tenant. Whether you're a landlord, whether you're an agent, tell them from the moment you meet with them in the property, tell them, I acknowledge this crack, this leak, or whatever the case is, and we are familiar with this, and we will get to this, but we'll also put it in the lease agreement. So remember, if there's things that you promise during the viewing that will be restored, or the damages will be fixed by the time they move in, remember to cover yourself to put it in the lease agreement. So to have open and honest communication with them will build trust, and it will build credibility. So then you can hopefully rely on the tenant to do the same whenever they come to a point where they can't pay the rent for the month because of unforeseen medical expenses. It's usually that. And, you know, there's the law, and there will always be the law, but there's also humanity. And just to intertwine the two and to be that bridge to say, listen, I get you. Life is tough. But I just want you to understand that I'm also dependable on this rental income because of A, B, and C. So let's see what we can do to mitigate the situation, to really just accommodate each other. This will immediately show that you as a landlord or you as an agent aren't cruel. You're not like a lion coming and growling for your rent. You're really just here to make everything enjoyable. So first one is open communication, to build trust and be honest and be yourself from the start. Then Alison also mentioned it as the landlord's responsibility is to do proper inspections. And you are allowed to do regular inspections. I usually done inspections every 6 months. I don't want to interfere with anyone's privacy whatsoever, but you are allowed to conduct inspections, obviously with the necessary prior knowledge to the tenant and to give them prior notice that you will come to do the inspection. So the very two crucial inspections is your incoming and your outgoing inspection. The tenant has to be present at the incoming inspection, and they have to sign the incoming inspection. If you don't get that tenant to sign the incoming inspection, it will be null and void basically at the end of the lease term. Then you cannot keep them liable for any damages unless your tenant is a super honest person. So make sure that you sign that incoming inspection with the tenant, walk through that property. And you know what, this can be another separate session on its own, but to really take time and take a look at each wall, each cupboard, open up, make sure the hinges work. And if there's any scratch or dent or mark or crack, note that and acknowledge it, saying we do take note of this crack. Don't worry, you won't be held accountable for that. That will already just place some peace of mind to the tenant, saying, okay, cool, my landlord is luckily open to know that this property isn't perfect, but also allow your tenant to live in the property. I mean, although they're a tenant, they also need some safe place, safe haven. So just be open with them and saying you are allowed, for example, to drill holes in the wall to hang your pictures and frames and paintings and all of that, because this is your home. But just note, again, a tip for the addendum of the lease agreement, that if you decide to do that, restore the property back to its original state, at least for that wall. There will be cracks and dents and all of that you will acknowledge in the income inspection, but the tenant has to give the property back to you in its original state. If you do not note this in the income inspection, or at least the addendum of the lease agreement, you cannot keep them liable for that at the end of the lease term. And then two things that's actually can be combined as one is there's so many platforms that allow you to privately manage your property. In South Africa, there's really software available that makes it super easy for you just to have some sort of structure, because all of these things need to happen at the same time. You have to do the vetting and then the inspection, or well, the lease agreement, then the inspection and all of that. But what is the order? What is the process? So be mindful, but also have the necessary knowledge for you to know what is the structure and the process of renting out a property. And this will then build your confidence to have the brain capacity to pinpoint whenever something is out of place. So there's a lot of software out there, many software platforms out there that you can use to manage your property privately, or then that you can use as an agent to do so. And in the same breath, usually those platforms also accommodate the invoicing of the tenants for the monthly rental. Usually you will be able to set up reminders, and you will be able to chat with your tenants. Some platforms actually has a chat ability to chat with your tenants directly. And those things, although it seem like, it's so admin, do that. Remind your tenants, send that WhatsApp, send that invoice. Because if that tenant failed to make rental payment, all of those reminders can be as proof for standing in court whenever an eviction needs to take place. So do those reminders, do the follow-ups, give that tenant a call, try and see what can happen or what you can do to help your tenant. But we should all be graceful towards one another, but there's also a point where you have to realize that this is your investment property. So just know that you can do the follow-ups, but please don't prolong it for too long and then you fall on the shortest end of it. So rather do the follow-ups in the time allocated according to the lease agreement. It's usually a week before the rent is due that you do those follow-ups. And then if the tenant hasn't paid by the 3rd or the 4th of the month, do one last follow-up, and then you are entitled to seek legal advice in the end to proceed with an eviction if that is necessary or if that is the route that you want to take. And then one last thing that I want to suggest is obviously to mitigate your risk. Again, as I said, this is your investment. It could be your parents' house that you've grew up in and now they've moved down to the coast to retire, but you want to rent out this property to form part of the estate at the end, but mitigate that risk. Rental insurance, landlord insurance, property insurance, make sure you have all of that in place, especially when it comes to property insurance. But also, again, note in the lease agreement, your property insurance will be for the structure of the building. It will not cover the content if there's any damages to the tenant's content, whether it's through burglary or whether it's through fire or acts of God, for example. So mitigate your risk. And again, if you need any help with that, we have so many specialized attorneys that's willing to take you through that process to make sure that you know, okay, I have my asset planning in place, I have my property secured, I have this and this and this insurance, or maybe this is not really necessary for them, maybe at the later stage, but just get that guidance and get that help to make sure you are protected in there. And so, yeah, this is just a few highlights. Again, there's so much more that we can delve into, but just make sure you do your homework in the end. And if you don't know, ask for help. There's so many platforms, so many experts out there that's willing to take your hand through this step, just to protect yourself.
I think the key word there is experts.
Yes.
Yes.
Yeah, absolutely. And so that does conclude our discussion. We have only 5 minutes left. Ladies, are you willing to stay on a little bit just so we could address a few questions? All right, so we've got quite a bit of questions. I want to mention to the audience, if you came in late and you missed half of the original discussion, I'm going to prompt you to take a look at the recording once it's made available on the PropAcademy website. So if we don't get to all the questions, we obviously have a time limit and we don't want to repeat. So apologies if we're not getting to every question today, but we will. I think in the meantime, maybe Marizel and Alison, you can share your contact details on the chat so that if there are questions that people can consult you with, I think that could also be helpful.
Don't worry, Charlotte has just posted it there for us.
Fantastic. All right, so let's get to the first question. And I did see a few that are a little bit repetitive, but let's get started. So Annie, I hope I'm saying your name right, is asking, do we not need consent to do the criminal check? And I think that relates to the first topic we discussed.
Yes. So whenever you do a tenant meeting, there's a few areas that you can make mention of this. Firstly is whenever you list your property, note that you will do the application, you will do background checks, and you will do criminal checks. So this already informs the tenant when they inquire about your property, this will be done. Also, when you give them an application form, note that there will be background checks done, which includes criminal checks and judgment checks. So the tenant you don't necessarily have to ask, listen, can I do this? Because no one really wants to have a background check done on them, especially if they know something is a bit off. But inform them. And then in the end, after they've completed the application form, they have to either tick or when they sign, they already acknowledge that I'm aware that these checks will be done. So yes, it's very important to ask your tenant or to tell your tenant, inform your tenant that these checks will be done. during the listing, during the viewing, and upon doing the application or asking them to complete the application form. Just note that there again, then there's 3 times, then they really can't say they wasn't aware of that.
Yeah, and if they don't want to do it, I mean, that already is a red flag that you need to consider.
Exactly.
Yeah.
Absolutely.
Next question is from Jennifer. So Jennifer is asking, I have a tenant that is terminating the lease agreement early. Her reason is that she does not have the funds. Can we keep the deposit?
So once again, we come back to the lease agreement. Your lease agreement, if you have a really good lease agreement, is going to talk about a cancellation penalty, how it's payable, and how you work and handle that deposit. If you have a good lease agreement, it will say that you cannot use the deposit for rental that is unpaid. There are 2 separate amounts. They need to be handled differently and separately. A lot of tenants try to get out of cancellation penalty clauses, but they are still going to be liable to pay them. So if you have a really good lease agreement, it comes back to being upfront and honest from the get-go and saying, look, this is for a year. If you feel like you have something coming up within that year, you're looking at changing jobs, let's do a month-to-month lease, or let's do a 6-month lease, that avoids the whole issue around cancellation penalties where people have to pay for months waiting for the landlord to get a new tenant, but you are perfectly entitled to ask for that. Now, have a look at your lease and see what that says. If you're confused, get in touch with us. We can guide you on your specific agreement. But just remember that as a landlord, you are entitled to charge a cancellation penalty, but you should not be charging for things like water and electricity. And I've seen this before where a tenant moved out of her property. She left the keys with the neighbor who had a good relationship with the landlord. Unbeknownst to both of them, neighbor was using the place to cook and have showers and using the landlord's utilities. And the tenant got quite irate because why was I being billed R1,000 for utilities when I wasn't even there? I put the DB board off, I made sure I put the geyser off, and now I'm being charged. So make sure that you know what that cancellation penalty entails. It is not as a rental charge. It is a separate penalty in and of itself. And if you are confused about that, ask your managing agent. But the correct answer is that no, she needs to pay her cancellation penalty. You then going to go in, you're going to see what damages there are to the property, get a reasonable quote. We always suggest get multiple quotes from different suppliers if things have to be fixed. And you then go ahead with deducting accordingly from the deposit and then repaying the residue that is left over, if any. So I hope that that will help guide you. But so many times people conflate money held with the landlord and money that is owed by the tenant. And you can't just automatically set those off. Okay, so if you are going to come to some sort of settlement agreement, make sure that you consult your managing agent or your property attorney and then get something in writing with the tenant. If you are on good terms and you're happy to just let it be, so be it, draft something up, but don't automatically assume that you can set amounts off without proper settlement agreements or consent from each side.
That makes a lot of sense. Next one is Janice. I have a client who manages his own property. The tenant owes him over 100,000 Rand in rent. The tenant out and he promised to pay the money back at 10,000 Rand a month, but has not. The landlord wants me to blacklist the tenant and trace him to get this money back. How do I go about this?
We would follow our 7 steps and we would get hold of a property attorney. And I think the issue here is that, once again, when you see someone is on their 2nd month of paying you late, you need to act fast. Most people are never going to have 100,000 Rand to pay you back. And even if you do evict them, you can get them out of the property, but there's no guarantee that we will be able to attach goods to make up for that shortfall in arrears. So get hold of your property attorney. You'd need to start the eviction process. You'd have to do it lawfully. You'd have to go to the courts and ask them to be evicted. Look, unfortunately, it's one of those things where it might be a sunken cost. And if you know this person is a bad debtor, you may not get that money back. But it's worth pursuing in court anyway. It's worth going after your court order and doing that eviction. But it just goes to show, we have so many landlords come to us when it is too late. And this is almost one of those issues where 100,000 Rand is a heck of a lot of money to be outstanding. So consult your attorney, make sure that you get your eviction application going, because for every month that someone is late and behind, you may be able to find a tenant who pays you on time and you don't have any shortfalls.
Fantastic. Thank you so much. All right. Next one is from Zunita. Zunita is asking, what do you do as a managing agent when the tenant refuses to accept the letter of demand via all communications?
This is an interesting one, but it's okay as long as it has been delivered to them. A lot of people will be very clever with the sheriff and say, well, you know, he doesn't live here, or I've never met the man and they've been married for 20 years and see each other every day. So like I say, remember, it's proof of delivery. You want to make sure that it was hand delivered to them. If they are verbally abusive with you, you still make sure that you get that proof over email. You can, you know, have all sorts of evidence that you've actually delivered that to them. And that's why I say use multiple platforms. Deliver it by hand, deliver it by email, and deliver it by WhatsApp. Get your blue ticks. You know, this is stuff that we have used in court before. You can use your delivery receipts, but if you see that a tenant's going to try and be clever with you, try and use multiple channels to deliver those documents. If you're feeling unsafe, you know, and you're not happy to do it in person, consult your attorney and they'll let you know who can deliver that letter of demand per hand on your behalf.
That's great advice. Thank you. All right. Nicole is asking, good morning. Well, we're now in afternoon. Good morning. If the tenant does not pay by the time the letter of demand expires, must the notice of cancellation be issued by an attorney, or can the agent send this?
So with the TPN pack, the landlord or the managing agent can send it. Just make sure that your format is correct. So this is the most important thing. It's not really important who cancels or sends a letter of demand. What is important is that obviously it's for and on behalf of the landlord, and you are duly authorized to act on their behalf, and that the contents of that letter are correct. But if you consult the TPN lease pack and the letters of demand that they have on the platform, those are 100% correct. And so when you come to your attorney, please don't leave it for 6 months either or a year. But when you come to your attorney after a reasonable time period and you've cancelled and you asked them to vacate and they haven't done so, your attorney can go straight ahead with the eviction application.
Right. Next, we're going to Partina is asking, what are the costs of an eviction order?
So SSLR has a specialized fee agreement. Marizel, I don't know if you want to pull that up, but we do it in phased billing. And so the costs are going to vary between which attorneys you use. So we always recommend to phone around, contact attorneys in your area. SSLR also has offices all over the country, so you can contact us as well. We have phased billing and we charge you per stage. Obviously, an eviction that becomes opposed is more expensive. So if you are wanting to determine a cost, remember in terms of the Legal Practice Act, an attorney, or that we now known as legal practitioners, we have an obligation to give you an estimated quote on what things are going to cost you before we do the work. And so we will always do that for you. So when you are looking around at costs and you're trying to determine what's affordable or come to some sort of payment plan with your attorneys, ask for those quotes up front so that you can see if it is affordable for you or not.
And this next question is almost like a follow-up question. Who pays the attorney's fee for the tenants refusing to remedy their non-rental payment?
So what's important to note here is that we get you to court, and depending on the facts of your case, and the magistrate will look at, you know, considerations around justice and equity. Generally, it will be the tenant who has to pay the costs if they have, you know, completely refused to vacate the property and they are an unlawful unlawful occupation. But in that application, we will ask for your tenants to pay the costs. Remember, you have to pay your attorney while they are rendering the services. We will ask that costs are paid by the other side, but we cannot guarantee what the court will hand down. So we can argue for you that the tenant pays the cost of the application, that the tenant pays your legal costs, but we can never guarantee outcomes because we aren't the magistrates and the judges making these orders. but a good attorney will ask for the other side always to pay the costs where they feel it's in the interest of justice, and it will be fair to ask the court for that.
All right, so next we have quite a long question, but I've read it already. It seems like it's got the similar gist like the previous question about using the deposits for rent not paid, but I'll quickly read it. So if a tenant is on a month-to-month lease agreement, he has been an excellent tenant for 2 years, always paid on time. However, on 1 November, he promised to pay the rent on 10 November, but he did not. He promised again to pay 30 November for the arrears November rent and for the new month, December. The landlord is only holding a damages deposit. My question is, what happens if the tenant doesn't pay by the end of this month? If the landlord only sends an LOD at the end of this month, the landlord will still lose out as he is only holding 1 month damages deposit. Not sure if it can be utilized for the arrears rent.
What's really important here to note is that month-to-month lease agreements are handled slightly differently from longer-term lease agreements. You want to get in touch with your property attorney. You want to show them that lease agreement, and they will then advise you on the most efficient way to make sure that the tenant is out. Remember, it's going to be slightly easier to get out of a type of lease agreement that's month to month. So don't leave it. It's month to month. Rather see if you can make an arrangement with the tenant, but try to cut your losses. And I think this is the important thing to note, is if you foresee problems coming, get hold of your property attorney beforehand, send them the documentation that they need, and let them advise you on the quickest and easiest way to get over the hurdles that you're experiencing with that tenant.
All right. Then we've got what happens, this is from Sharon, what happens if a tenant doesn't pay their last month's rent? I think this has been covered, so we can maybe move on. Then Carmen is asking, what happens when you have a new tenant that viewed the home and was happy, but when I placed them, they only paid the deposit, but is withholding the prorate until all issues are sorted out?
Once again, go back to your lease and see what your lease agreement says. Remember that you've got to pay a deposit, but you also have to pay your first month's rental. Yeah. So whatever that person was quoted, they have to pay. It might be time to start issuing a letter of demand and to go back to the checks that you've done. So where you can see this is already a problem, sometimes all it takes is your attorneys getting in touch with that tenant to get them to sort things out. If you are breaching your obligations as a landlord, also try and remedy those as soon as possible. I know we're all desperate to find good tenants, but make sure that if there are serious issues in the property, that you have an open conversation and that you commit to fixing it by a certain time. Tenants often get frustrated when they move in, they were told something would be fixed, and now it's not fixed, and it's basically making the property uninhabitable. So really important to get hold of your attorney and to see how you can aim to resolve the disputes that both sides have.
All right, I do think we have a bit of a repetitive question here, but I don't want to dismiss anybody. Obviously, Alison, Marizel, you can make that decision. So Melody is asking, when a tenant terminates early because they have bought another property, may the agent or landlord withhold the deposit and charge up to 3 months rental? What happens if the tenant refuses to pay cancellation penalty? No other tenant was placed.
So once again, this comes back to the fact that you do have to pay a cancellation penalty, given that it's reasonable. If a tenant really feels that they don't want to pay something and they're being asked to pay something, they can always approach the Rental Housing Tribunal for some sort of alternative dispute resolution or mediation process. But if you are at the point and it's quite a lot of money, approach your property attorney and see how you can institute a claim for that cancellation penalty. Remember what we said before, you can't just offset amounts as and when you see fit, but we have to see that lease agreement. Unfortunately, it's so difficult to advise, and we can't advise on an open platform like this because every lease agreement's different. It's going to depend on what's in your lease. It's going to depend what you've said to that tenant, how your cancellation penalty invoices look, because some of them are incorrect and you need an attorney to guide you on how to correct them. And it might be something as simple as amending the penalty charges and then the client's happy to, or the tenant's happy to pay it. So get hold of your property attorney. Let us have a look through your documentation and we can advise you on the way forward there.
I think since we're on the 10th minute now, going over our session, I'm going to give you one more question, and then just to everyone, apologies if we don't get to all the questions. I think if we would allow, we could go on all day, because there are a lot of scenarios that come out of rental situations and tenants, and I think we all know this. We can try and discuss with Marizel and Alison to have a follow-up session. We'll just have a look into that. So apologies if we're not getting to all questions. Obviously, we know that this is a very loaded topic, so we do keep that in consideration, but the webinar will be made available to everyone to go back to topics, revisit some points that were made. So I think I'm just going to do one more question, ladies, and then we can conclude. So Amuri is asking, how will a landlord go about an eviction if they live overseas?
So what you should do is make sure that you consult your attorneys. It's not impossible. We've got plenty of clients who are overseas. It also depends on what kind of eviction we're talking about. If you're running a company here, you've got some commercial properties, it's a little bit easier because you'll usually have directors that you can have a resolution passed and they can act on your behalf, or we can get some sort of power of attorney for someone here to act on your behalf. Remember, your attorneys are there to assist you with that as well. So just because you are overseas does not mean that you can't institute legal action here and protect your assets here. There are many ways for us to get around that issue. So consult with your attorneys. SSLR is also around to assist. We can then view your different structures and we can see, all right, how can we make this workable? But a lot of the evictions, remember, it's an application process. So everything is done through affidavits, and we are therefore able to, it's not going to be like your Boston legal, we have to stand up on the stand and you're in front of Judge Judy. It's a little bit different. And so it is a lot easier for us to assist clients who are overseas as well. So get in touch with us. Let's see how we can help you, but it's not something that will bar you from getting bad tenants out of your properties in South Africa at all.
Thank you so much. And I think, again, we're just going to conclude there because we do have a time limit and we've already gone over it a bit. Thank you to everyone who's attended. I want to say personally thank you from C2 Training Solutions of PropAcademy side. Thank you to our guest speakers, Alison and Marizel. We really appreciate your insightful knowledge and your information and the brilliant advice you've shared. I think it's been very valuable. And definitely we will be in touch with you to have future sessions again. Just a reminder to all attendees who are still here, all contact details have been shared in the chat. Please feel free to make use of it and reach out to Marizel or Alison directly if you need additional advice. And of course, Courtney McKenna and Charlotte Nathanson are also available from PropAcademy side if you would like to make further connections or find out more about our courses related to the property space. But yeah, Courtney, maybe just a conclusion from you and then we can end off.
Yeah, sure. I would love to carry on talking, but I can't because I know Colleen's going to cut the meeting. But just in closing, I just want to say to anybody who is placing a tenant, and I wanted to mention it much earlier, and I'll be very quick, it's just a red flag tenant. So we have it with all businesses. You get a red flag client as somebody who shouts at you, who rushes you, and who comes 2 days before they need to move in. Those are your red flags. I think you need to sit down, don't take the pressure that they give you, and slowly go through the process. Don't miss a beat just because you're being put under pressure. Thank you so much to both of you ladies for joining us. It's been absolutely insightful. For all the questions that haven't been answered, we will certainly make sure that we send them through to the two ladies. And as Colleen said, your contact details are there as well for you to reach out. Thank you, everybody.
Thank you.
Thank you. Thanks for having us.
Wonderful afternoon, and it's almost the weekend. Bye, everybody.
Bye.
Bye. Thank you. Bye-bye.